I have no guarantee that she's going to make it even to treatment.
Yeah, I promise you I will. I have my 4 kids with me, sir, Your Honor.
You know, she has a lot at stake.
I understand that, including her life. She test clean today.
I'm sorry?
Will she test clean today?
I'm not sure, to be honest.
You're not sure?
I haven't used, I know that, but I don't know.
When's the last time did you use?
A couple days ago. That's why I'm seeking in-house treatment.
On the 6th. She's positive on the 6th. I'm now here on the 12th. And she's using by the 10th.
Can you state your name for the record?
Yeah. Larry Evans. Thank you.
Thank you. Your Honor, we were just asking to set this matter for preliminary examination, discovery complete to the best of my knowledge.
People have their witnesses available the 24th. You might be. Preliminary examination will be set for March 24th.
Is that what you want me to do?
2026, 9 a.m. before judge. For me.
Your Honor,
Yes.
if I may briefly address bond. Your Honor, my client is asking for release on PR. He advises that he is just trying to get back to work at this point. He advises that he would be able to and willing to obviously show up for his preliminary examination. This is a matter that he certainly wants to handle and take care of. He does have a place to stay locally. He's got family that supports him. Is that all correct? And
Yes, it is. Response.
He also has bowled out of Detroit for retail fraud, bond denied, and larceny in the building. This is an extremely serious case in which the victim was at the defendant's apartment trying to leave, and he told her no, threw her on the couch. He then told her to stay before I came. She was able to use the phone to tell her friend to call 911. He then took that phone and went to the bathroom with it. She then ran to try and escape the apartment, and he wrapped his arms around her neck, pulling her back to the apartment by her neck and her hair. While inside, he then dragged her into a bedroom, threw her on the bed, and then strangled her, saying, "Bitch, I will kill you." He eventually stopped strangling her and told her she could leave, but when she tried to leave, he closed the door and again threatened to kill her, and then grabbed a 2x4 and raised it as it hit the victim. She had bruising, red marks, and raising herself from this instance, so I would strongly object to anything.
Anything else?
just looking at the size here versus the allegations, Your Honor, I'm not sure how all of that was very easily accomplished. Obviously, they're allegations at this point. So again, I'll just.
He had a hard time doing exactly that.
I'm not saying that he at all, obviously.
For bond reductions, bond will continue.
Right. Be in touch.
It's his birthday. No, I'm every week. Court calls the case, People versus Sean Charles.
Assistant Public Defender Jay Bellinger on behalf of Mr. Charles, who appears via Zoom, Your Honor. Mr. Charles,
Oh, there she is.
for the record.
LaShawn Charles.
Thank you.
And Your Honor, we are just asking for an adjournment on this matter. We are seeking to get upper management involved for purposes of a resolution in this case.
Probable cause conference will be adjourned April 2nd, 2026. And bond continue.
Thank you very much.
Thank you very much.
Thank you.
You're welcome.
Court calls the cases of the People versus Walter Peterson.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Robert Ellman with and on behalf of Mr. Peterson, who's approaching. And Mr. Peterson, when you get up here, can you please state your name for the record?
It's Walter K. Peters.
Thank you.
Your Honor, the people have actually just made me an offer this morning. We need some time to go over that with Mr. Peterson. I would note I've spoken with him about his bond. I do know that I believe it's currently set at 1,010%. Unfortunately, that's still an amount that Mr. Peterson can't post. I'd be asking for this time a PR bond, or in the alternative, Mr. Peterson has expressed a desire to be released to treatment, if that was an option on the table.
In order for release to inpatient, but his bond will continue. I'll adjourn this matter to March 26, 2026, 9 a.m.
And Your Honor, just, he has a misdemeanor matter in front of Your Honor as well that I believe he also has a bond on. Can I submit an order in that case as well?
For release to treatment.
Yes, Your Honor. Thank you.
Thank you. Got to keep moving.
Yes, sir. Yes, sir. Gotta go.
Court does call the case. People versus Douglas Crockett.
I'll check. Well,
And it's the plug defendant for Nicholas Bukovich and Mr. Crockett, who should be appearing via Zoom.
Yes, here. Where? Oh, there he is. Mr. Crockett, can you state your name?
Douglas Crockett, good morning, Your Honor.
Good morning, sir. All right.
We're just asking for adjournment for a little bit of time to talk about discussing the case with my client and negotiations.
Okay, probable cause conference will be adjourned to April 2nd, 2026, 9.
Understood. Thank you, Your Honor.
Thank you. Thank you. Bond
Thank
will
you.
continue. Court does call the case. People versus Bernard Gray.
Then on behalf of the people,
Veronica Glenn on behalf of Mr. Gray. Can you state your name for the record?
Bernard Gray. Okay, what are we doing?
Your Honor, we would like to set this for a preliminary exam.
Sure, co-defendant. People have their witnesses on the discovery is complete, correct?
To the best of our knowledge.
Pardon?
To the best of my knowledge.
People have their witnesses available 24th. Preliminary examination in person, March 24th, 2026, 9 a.m. before Catch Fresh Hour. Bond will continue. Thank you.
Thank you, Your Honor.
Get this one out. Court recalls the case of the People versus Terry Williams.
Again, Your Honor, Raymond Cook for the people.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Williams. Mr. Williams, can you state your name for the record?
Terry Williams.
And Mr. Williams, can you start your camera?
Okay.
And also, Mr. Williams, I'm standing in for your attorney of record, Brandon Burton. That is with your permission. Is that correct? Good morning, Your Honor. Skype number 8179.
I'm trying to connect my camera. I don't know what's going on. It's not letting me turn on my camera.
All right, I'll let it pet. What are we doing?
Your Honor, we're just seeking a brief adjournment. I know that there's going to be a waiver executed in this matter. I just didn't have an opportunity to get the paperwork signed prior to today's date. So we're just asking for a brief adjournment so that paperwork can be executed.
Probable cause conference, March 19th, 2026, 9 a.m. Sir, if you appear via Zoom, you will have to make sure that you have a camera. You understand that? Otherwise, you need to be here in person.
Yes, sir.
Bond will continue. Thank you.
Thank you so much, Your Honor.
Court does call the case of the people versus, well, hold on, you guys. Thomas Mashka.
Andrew Childers, defendant.
What is it? Court shall be the assistant public defender on behalf of my client. Please state your name for the record, sir.
Thomas Kumasaki.
Thank you, Judge. My office has spoken to my client. They are still trying to negotiate a resolution. We are asking for a brief adjournment.
Probable cause conference will be adjourned March 26th, 2006, 9 a.m. Bond continued.
Thank you, Judge.
Court does call the case of the people versus Ryan Sitanlon.
Andrew Childers, defendant.
Veronica Glenn on behalf of Mr. Donlin.
Morning, Your Honor.
Morning, sir. Your name?
Ryan Douglas Donlin.
What are we doing?
He would like, our client would like to enter a plea.
I don't, you're just turning, my staff doesn't have the paperwork. Not the way we do it. My staff first, but. Plea form indicates that the defendant is gonna plead to count 2. The methamphetamine, that's a guilty plea. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
May I have him sworn?
With your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the whole truth and nothing but the truth, so help you God?
Yes, I do.
State your name, please.
Ryan Douglas Donlin.
Sir, it is this court's understanding you're gonna plead guilty to the charge of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
There was to plead guilty,
Yes, Your Honor.
and to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, I believe so.
Well, did you sign this form?
Yes, that's the one. Yeah.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
Saying you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I'm currently on probation, Your Honor. Yes.
Were you on probation at the time of this offense?
No, Your Honor.
Anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of June 10th, 2025, at the location of Gettys Road, Ann Arbor Township, Washington County, State of Michigan, did you have methamphetamine in your possession?
Yes.
Use it?
Yes.
And did you know what you were using as methamphetamine?
Yes.
Sir, if I accept your plea, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would no longer be able to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
I understand.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am not.
No, no.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's guilty plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
24th at 10 a.m.
March 24th, 2026, 10 a.m. 10 a.m. before Judge Barr. Bonds will continue.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Nicole Murdoch.
Michael Getty, Assistant Public Defender on behalf of
His approach and which.
Nicole Murdoch.
Have before me a plea form indicates she's pleading no contest to the charge of attempted resisting and obstructing the 1-year offense. On her successful plea to that charge. Count 2, count 1 would be. There's also a sentence agreement to a prosecutor's deferred. And that is the court's full understanding of the agreement.
That is correct, Your Honor. I have gone over that agreement with her rights, as well as any sentencing
I have her
waiver.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the truth stuff?
Yes, sir.
State your name.
Nicole Murdoch.
Murdoch, it's this court's understanding that you're going to be pleading no contest to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. Do you understand that?
Yes, sir.
All right. You understand what a no contest plea is?
Sir, I do.
Things about it, I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentence, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
And you understand that while I'm taking your plea, I would not be your sentencing judge in this case. And you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, sir.
Still wish to plead no contest?
Absolutely.
Faith for the no contest plea?
Potential civil liability, Judge.
Ma'am, to that charge, plead.
No contest.
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
Signed any advice of rights form or had one caused to be signed on your behalf?
Yes, sir.
Question regarding rights?
No, sir.
Look at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything? You didn't need to get you to plead.
No, sir.
Anybody threaten you or coerce you?
No, sir.
And this voluntarily and of your own free will?
Yes, sir.
Court has been provided and has reviewed Washington County Sheriff's report for their case number 267438. Any objection to the court having reviewed that report?
No, Your Honor.
Upon a review of that report, the court does find that there's a sufficient factual basis. The court could determine the defendant's guilt to this offense. And I do have to advise you, the time I accept your plea and the time of sentence, misconduct as defined under the Michigan court rules would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or record.
Yes, I do, sir.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
None from defense, Judge.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation report is ordered. Court sentencing in this matter will be April 6, 2026, 9 a.m. before Judge Freshour. Bond continued.
If I could be heard on bond, Your Honor.
Mr. Bond.
Your Honor, Ms. Murdoch is, she was here last week. The court began to take a plea. There was a bond violation for a positive test. Ms. Murdoch explained what she thought could have given rise to it. I've met with her. She turned herself in as the court directed the following morning. I've met with her on this matter and discussed the matter at least twice now with her, and she fully understands that it is her obligation to refrain from doing things that the court has ordered her to, refrain from doing either intentionally or in anything that goes into her body, even by mistake, is on her. I believe that she's a good bet to comply with the court's orders moving forward. She is gainfully employed. She has a good job. Fortunately, she's been able to use PTO while she's been incarcerated this week, but that will not continue. She has a family. She lives, not a flight risk in any way. Effort to give her one more chance to demonstrate to Your Honor that she is a good bet to follow all the court's orders moving forward.
Anything from the people? Defendant's previous bond, including testing, is reinstated.
Thank you, sir.
Thank you, Your Honor.
Court calls the case of the people versus Kenzie Dunn.
Michael Gaddy, Assistant Public Defender, on behalf of, make your way to the podium.
Your name?
Oh, I'm sorry, Kenzie Dunn.
Your Honor, I have submitted a green sheet. We're asking for an adjournment. Ms. Dunn has a assessment at the Sacred Heart treatment facility tomorrow. I do have a verification here. It's the Sacred Heart program that's up in Richmond, which I think is up in northern Macomb County. It looks like it's their model is a 12-step type approach. It is inpatient.
On an amphetamine of some type?
Excuse me, Judge?
On an amphetamine of some type?
You mean prescribed?
Have
Yeah, I don't believe so, Judge.
this should be clarified. So why is she testing positive for amphetamines?
Your Honor, I believe this was the initial test after arraignment. We are asking for an adjournment
Will she
for.
test clean today?
I'm sorry?
Will she test clean today?
I'm not sure, to be honest.
You're not sure?
I haven't used, I know that, but I don't know.
I think she's. It's my understanding she doesn't know the half-life of it, Your Honor. I believe her initial test was.
That was she
6th
saying?
Or the 5th. Well, she
When's
said,
the last time did you use?
It was a couple days ago. That's why I'm seeking in-house treatment. Your Honor.
Your Honor, I do have, documentation here that she is seeking to address the root cause of any of this behavior. Like I said, she has an intake tomorrow. I can, it's at 1 p.m. That's in Richmond. She is here, this issue today. I can offer it to the.
She tests on the 6th. She's positive on the 6th. I'm now here on the 12th. And she's using by the 10th. I have no guarantee that she's gonna make it even to treatment.
Yeah, I promise you, I will have my 4 kids with me, sir, Your Honor.
Your Honor, she has a lot at stake.
I understand that, including her life.
Yes, Your Honor.
I'll adjourn the probable cause conference. March 19, 2026, 9 a.m. This time the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Court calls case People versus Amber Dunson.
The judge.
Al Chabalowski for the people.
Court shall cease the Assistant Public Defender on behalf of Ms. Dunstan. Approaching the podium. Please state your name for the record.
Amber Dunson.
Thank you, Judge. We've spoken to the people in this matter. There's a potential offer in this case, but it's going to require a large financial component to it. If we could go out at least 4 weeks, then we could see if that's even a feasibility or not, Your Honor.
Any objection?
Oh, yeah.
Probable cause conference will be adjourned April 9th. 2026, 9 a.m. Bond continue.
Monday or Tuesday, we'll talk. Thank you, Judge.
Court calls case People versus Devon Gibson.
Your Honor.
Carolyn Foster Tucker on behalf of Mr. Gibson. Can you state your name?
Devin Gibson.
Thank you.
Your Honor, we're seeking an adjournment just for additional time to review discovery.
Probable cause conference will be adjourned March 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Here. Court calls case People versus Jacob Pike.
Your Honor, Raymond Cook for the people.
Jacob Pike present.
Morning, Your Honor. Philip Kavanaugh, substituting in for the public defender. And I believe my client, Fike, is on video. And we have.
Pike, can you state your name, please?
Jacob Pike.
All right, what are we doing?
I believe that we've come to an agreement with the prosecutor. And this was just reached, so Mr. Fike has not signed it, but both attorneys have agreed, and I have talked to Mr. Fike. He is video conferencing. I believe the court gave him permission, but he is a laborer and a skilled tradesman, is out of state right now, as he was last week. But he wants to assume all responsibility for the act. Fully employed. Children.
Here's the plea form. Plea forms have to get, has he signed, counsel, has he signed an advice of rights, or does he put an advice of rights with?
I told, honestly, I cannot say so myself.
All right.
Over.
Well, hold on.
I could
give back to. I'm not gonna. I would normally take plea. I don't have a problem doing it, but I'm gonna put it out to make sure he's advised of all of his rights prior to entering the plea. You want an adjournment of 1 or 2 weeks, counsel?
1, quick as possible.
Will that work for you, counsel?
Yes, it will, Your Honor.
Probable cause conference, March 9th, 2026, 9 a.m. Bond continued.
Thank you.
Well, court calls case People versus Jimmy Perry.
Michael Gaddy, Assistant Public Defender for Mr. Perry, is making his way to the podium, Judge. State your name for the record.
Jimmy Perry.
He's seeking an adjournment. He wants to retain counsel.
That is correct, Judge.
How long is that going to take you, sir?
30 days, no more than, I'd say about a month, no more than a month and a half, Your Honor.
Well, I'm not going to give him a month and a half, but
Your Honor, would you consider the first week in April?
first full week or first day in April?
First full week, please.
All right, I won't adjourn it again for this purpose. You understand that, sir?
Yes, sir.
April 9th, 2026, 9 and bond continue.
Thank you, Jeff.
Thank you. Court does call the case People versus Tania Freeman.
Michael, Assistant Public Defender on behalf of Ms. Freeman. She should be here by Zoom, Judge.
Ms. Freeman?
Hello, I'm here.
Oh, state your name.
Deanna Freeman.
Your Honor, we're asking for a very brief adjournment. I believe that the people have made an offer that Ms. Freeman wishes to avail herself of. I just need to get to the paperwork.
March 26, 2026. Bond continue.
Thank you.
Thank you.
Thank
Court
you.
calls case. You're welcome. Court calls case People versus Mamadou Kaba.
Judge.
William Amadeo, P 76194 for Mr. Kava. Please state your name.
I'm Cabo.
Okay, turn this way. All right, what are we doing?
They're just setting this for a prelim.
Discovery is complete.
I believe so. Yeah, I know. Judge, I just want to make a record. We don't get a prelim today. We need it at the earliest date, please. I want my client to make sure he knows that. Since this is a probable cause conference, you can't, no, we're not adjourning anything. We're just going to the prelim.
You have all the discovery.
I believe so, sir.
You will have their witnesses available the 24th. Probable cause or preliminary examination will be set in person, March 24th, 2026, 9 a.m. That's before
Thank you.
before Judge Fresh Hour. Bond will continue.
Thank you.
Thank you.
I need this.
Court calls case People versus Dallas Fritz.
And on behalf of people, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Fritz, who should be hearing via Zoom from treatment, Your Honor.
Dallas Fritz.
Hello.
Hello. I need a camera.
There we go.
There you go. Okay.
All right, Your Honor, we were otherwise prepared for a plea today. However, we understand that Mr. Fritz has some significant issues in Oakland County in terms of his probation that he wants to look into prior to taking the plea here to see what the consequences might be. So we would just be asking for 3 weeks. We've all been trying to reach out to his probation, including him.
Oakland. He's currently in treatment.
That's my understanding, yes.
Is that right, sir?
Yes, Your Honor.
All right.
Do you have a potential release date, Mr. Fritz?
Not as of right now, but I can get that probably today if you need it.
Okay, great. All right, thank you.
Probable cause conference, April 2nd,
Thank you very much, Your Honor.
2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir. Court calls versus Theophilus Smith.
Good. Sit tight. Ready, Judge.
All right. Seeking an adjournment of this.
Yes, Judge. Could we please have a couple of adjournment?
During this March 26, 2026, 9 a.m.
And Your Honor, if I can respond.
May.
Your Honor, at this point, I'm gonna be asking for the defendant's phone privileges and texting privileges to be revoked. I have 23 calls to the victim's number from his, in the latest call being yesterday. In his calls, the victim was mentioned by name, they talk about the charges that he had court today, so at this point, I'm gonna be asking for phone privileges and texting to be revoked.
Any response?
No, Judge.
Defendant's phone and text privilege hereby revoked pending hearing.
Thank you, Judge. We'll go cut the call.
Yeah, I mean, he's a fan. Okay, well, let's.
I'll give them to me.
Court calls case People versus Zariah Griffin Bills.
Your Honor, Raymond Cook for the people.
This is Public Defender Jay Bellinger on behalf of Ms. Griffin Bills. Ms. Griffin Bills, can you please state your name for the record? Always have.
Yeah.
All right. I have before me a plea form. Is that what we're doing today?
That is the plan, Your Honor.
All right. Plea form indicates that the defendant is going to be pleading count 2, added count 2 of assault and battery, the 93-day offense. Upon the plea of that charge, count 1 will be dismissed. That's the court's full understanding of the agreement.
That's right, Your Honor.
That is our understanding as well, Your Honor. Is that your understanding?
Yep.
May I have her sworn?
Right here. These about to give will be the truth, though. So we got.
Yes.
State your name, please.
Sorry, Griffin Bill.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to $500 fine plus court costs. You understand that? Understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th district.
Yes,
Don't want to plead guilty
yes,
to that charge. How do you plead?
guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes,
Signed in advice of right or had one cut or had one signed on your behalf. All right. Do you have any questions regarding those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will. Yes. And because you believe that you're guilty of this offense? On dated December 1st, 2025, at the location of 114 East William Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do on that date involving a Mr. McKeon that makes you think that you're guilty?
I got into an argument with him and he grabbed me and I hit him. Multiple times.
Pardon?
I got into an argument.
Grabbed you and then you hit him?
And you hit him multiple times,
Yes.
and that was a force that was greater than his.
No, but yes.
No, but what? Well,
I mean, yeah.
I don't know that I can accept it.
I understand, Your Honor.
So what do you want me to do?
Your Honor, I would ask that if you're willing to either pass this matter so I might have an opportunity to speak with her or give us a new date.
So your birthday?
It's St. Patrick's Day next week.
Your birthday?
It's
Oh, it's Saint.
I'm Irish.
Claiming the Irish saint.
I'm Irish.
Nope, won't work. I'll give you a new date. Probable cause conference. I'll adjourn this out to March 26, 2026, 9 a.m. All right.
All right, thank
Her
you.
bond will continue. Thank you. Court does call the case People versus Jason Hahn.
Alex Jablowski. And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Huff.
Jason House. Thank you. Go ahead.
At this time, Your Honor, we will be requesting an adjournment for a little bit more time for free negotiation.
Probable cause conference. I'll adjourn to April 2nd, 2026, 9 a.m. Bond continue. Thank you.
Your Honor.
Court does call the case People versus Michael Bank. They're unable to. This is Oakland.
Michael Gaddy, Assistant Public Defender for Mr. Bank, Your Honor.
See the message from a legal assistant in our office that Oakland County notified them that they won't be able to get to the front of a camera today. I asked if they gave any reasoning and they implied that there were scheduling issues. Or that's why it's not sure what happened, but I don't think that they are going to bring.
Oakland signed on. They can't bring him out. Is that? Oh, got it. Okay.
Aside from that being part of their reason for being judge, I was gonna ask for an adjournment anyways, because I haven't been able to meet with him yet. We're going through their process of the virtual meetings.
Oh, okay, because you haven't been able to got it.
Which I think,
April 2nd, 2026, 9 a.m.
I think I'll be required to take my first selfie in order to accomplish it.
I know. Wow. You know, Mike, have somebody take a picture of you. Yes. Yeah, that's going to be it. Court does call the case People versus Edward Harris.
And this is on behalf of people, Your Honor.
Speech.
Veronica Glenn, on behalf of Mr. Elwers, can you state your name for the record, please?
Elwers.
We would like to adjourn this matter for mitigation and negotiation.
I'll adjourn all of these matters to April 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Court calls case People versus, is it Leah Winter?
Veronica Glenn, on behalf of Ms. Winter. State your name for the record, please.
Leah Renee Winter. Hyphen over there, Renee.
You're requesting a forensic evaluation.
Yes. We need time to, yes.
Forensic evaluation is hereby ordered. I have signed the order. I will set a competency hearing 90. June 11th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Robert Harris.
Assistant Public Defender Jay Bellinger on behalf of Mr. Harris, who should be hearing via Zoom, Your Honor.
Robert Harris?
Yeah, that's me. I'm
That's
Robert.
you?
Sir.
Okay. All right.
Thank
Can you use it?
Your Honor, we are just seeking an adjournment. My client's in the middle of collecting restitution for purposes of an offer here. We're about halfway to where he needs to be at this point.
How much more time does he need? Because
Realistically, Mr. Harris, if you were to collect $2,000 more in total, how much time would that take you?
2 more thousand. It won't take long. It's like 2 more weeks. But can I say something real quick?
Mr. Harris, I just need an answer to that question. If you would, we can talk after court on the rest, but how long realistically would it take you to come up with $2,000 more?
Can you do it by April 2nd, Mr. Harris?
What is it, March? I could try that. Yep. April 2nd.
Okay, well, let's do this. Probable cause conference. Give him a little bit. April 9th.
Yeah, that's great.
2026, 9 a.m. All right. So I'm gonna give you almost a month. Come up with that, get it done. All right.
Yes, sir.
Thank you,
All right.
Your Honor.
Thank you.
Thank you, Lord.
Court calls the case. People versus in Hightower.
Your Honor, bringing cook for the people.
Veronica Glenn appearing on behalf of Mr. Hightower.
Your name?
Kenya Hightower.
Okay. What are we doing?
Your Honor, my client would like to waive.
So you're waiving your right to a preliminary examination?
Yes, sir.
We understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor, there was an offer extended. If I can put that on the record.
Yes.
The offer was to leave up and eat on things like that.
Okay. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Your Honor, my client stands mute and we will waive formal reading of the information and we ask that you set this case for pretrial.
Waive for defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea trial. will be set for
Judgment.
May 4th, 2026, 1:30 for Judge Hamud. Bond will continue. Thank you.
Thank you, Your Honor.
Appreciate it. Court calls case People versus Jalen Johnson.
Assistant Public Defender, Tanaka Perry, I can rule, Your Honor, on behalf of Mr. Jalen Johnson, who should be on scene.
Jalen Johnson. Mr. Johnson? Or Miss Johnson, I don't know. Jalen Johnson? Really?
Your Honor, I spoke with Mr. Johnson earlier today.
Right, he's on the screen.
Oh, can you see him? Okay.
I can see. I can't see him. Just not talking. Chinaza, why?
I know, Judge.
You know, if this were Mr. Bukovich's client, they'd be ready to go. I'm just saying. How much longer should we wait?
No, not
Like waiting for you after I call your case.
my walk is much longer. I'm just gonna ask for an adjournment today.
I know, but I gotta have the person.
I've texted him.
You?
Yes,
How'd that go?
nothing yet.
Answering you? I'll pass it briefly.
Okay.
All right.
Your Honor.
Sure.
I will.
Court calls the case, People versus Lamine Kaba.
Michael Gaddy, Assistant Public. Your Honor.
Your name, sir?
Kaba. And we're asking for a brief adjournment. I have filled out the paperwork to get Mr. Kaba fixed up in the to be assessed in the mental health treatment court. If I could approach, I have the referral form for Your Honor to review. Oh, I believe this may have to go with it.
Yes. I'll adjourn Mr. Kaba's case to April 2nd,
Thank you, Your Honor.
2026. On continue.
Call these folks tomorrow morning, okay? It's this number. Okay? All right, call me if there's. All right. All right.
What? Why are you bothering Allie? Are we doing her? Yes. Nah. Penitence. Court calls the case, People versus Awazi Khan. Oh, was it? Probably said that first name wrong.
Laura Yaki, Assistant Public Defender with on behalf of Mr. Khan. Could you state your name to the court? And Your Honor, we are requesting a brief adjournment. I have a preliminary offer. I need some more time to look into it and to discuss it.
April 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you.
Court calls case versus Brandon Robertson.
And Lord Yagi, Assistant Public Defender with and on behalf of Mr. Roberts. Is it perfect name? You say your name to the court?
Brandon Roberts. Nick took his chain in, take his scarf from off. Chain.
Leaving me.
Apologize, Your Honor.
All right.
I am requesting an adjournment in Mr. Robertson's case. a variety of reasons. I need more time to go through it, discuss it, and I think there might be some outstanding discovery as well. I haven't signed a protective order, which I know we usually have to sign to get the interview in this.
So that we haven't even gotten, okay, gotcha.
Get a protective order over from today.
Thank you.
All right. Probable cause conference, I will adjourn this matter out. Is there gonna be extensive discovery in this, or?
I'd say extensive, but there are forensic interviews.
I think.
April 9th, 2026, 9 a.m.
Thank you. Thank you.
Court calls case people versus Ed Thompson.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Thompson. I do know Ms. Thompson just stepped out to go to the restroom, so may I go peek for her in the hall?
Fine. Wainwright is refusing. Court calls the cases of people versus Stephen Wainwright.
Stephanie Cannon on behalf of Mr. Wainwright.
Oh, she finds it. Really?
Yes, Your Honor. I was trying to claim Irish heritage as my
For you?
coworkers did, but unfortunately, I don't know if I'm going to pull it off. So. So we're just asking for an adjournment of this matter, Your Honor. He already has forensic or competency evaluation orders in the other files. We just needed to get them in. So.
Oh, okay. Since he's not willing to come up. So, what I will do, what date did we set the competency?
It's in Hamud where the competency is.
Oh, it's already up.
Yes, he has one felony matter already pending in front of her.
Okay, so what I'm gonna do is I'll adjourn it out to, since he's not he's refusing in this case, I'll adjourn it out to April 9th. With this one, what I would do if there are competency pending, if you want to submit that by step, indicating that it's pending, and then along with the requisite orders, and then I can sign off, reset the date.
Thank you, Your Honor. Will do.
Thank you. Shareholder, what's this? Just thought that this is, she here now?
This is
Hmm?
difficult
This is a recall.
for, Johnson.
That's right. Laquita Thompson.
And Assistant Public Defendant Nick Bukovich on behalf of Ms. Thompson, who's now approaching. Can you please state your name for the record?
Laquita Thompson.
All right. What are we doing? You're seeking an adjournment?
Yes, I am seeking an adjournment, Your Honor. And I'm prepared to address the corrections report.
Pardon?
I said there was a note for community corrections reports. I'm prepared to address that.
And on February February 22nd, she blew numbers. We're at her 3 blows, then she took an EEG the next day. It came back.
Yes, Your Honor. In addressing the alleged violation, my client does indicate he does admit to drinking on that 22nd date. It was unfortunately she did lose a friend of 24 years, someone she worked for and has known for a very long time. And unfortunately, as part of the grieving process, she does admit she did have a moment of weakness and there was a mistake and she did drink. She is working very hard on maintaining the good strides she has made in her life. She currently works 2 jobs, one where she works approximately 12-hour shifts on her feet at a manufacturing factory. She has done community service. She attends AA meetings. I actually do have AA sign-in sheet that I can provide to the court and the prosecution. She attends them both in person when she's able to, and on Zoom when her work schedule does not allow her to make in-person dates. I do want to note, prior to being placed on the prior to being placed on the sober link, she did have no violations on the Scram tether. She had to be placed on the sober link due to issues with her ankle, and that was why at the previous PCC date you allowed her to switch over to the sober link. I do note I do understand there are several late tests. However, I do want to note several of those tests she did test within 10 minutes after the time frame occurred. I think 7 of those total. And for all of those late tests, she was negative. She does, as I indicated, work on a
defendant will actually make it to treatment. I have no guarantee she'll even make it there, the judge says. The defendant promises she will, explaining she has 4 children and a lot at stake. Her attorney adds that she tested clean earlier, but when the judge asks directly if she would test clean today, the answer becomes uncertain. Pressed further, she admits the truth. The last time she used was a couple of days ago. That admission changes the tone of the hearing. The judge points out the timeline. She was supposed to be clean earlier, yet the pattern suggests she used again shortly after. The defendant pleads for in-house treatment, hoping it will give her the structure she needs to finally break the cycle. Question: when someone admits the truth in court, should judges give them another chance for treatment? Like and share if honesty should count for something.